Joining us now with his reaction, criminal defense attorney Bob Bianchi. Bob, thanks for coming on today. Rittenhouse, as we know, facing multiple charges, including first-degree reckless homicide, first-degree recklessly endangering safety, first-degree intentional homicide, attempted first-degree intentional homicide, and possession of a dangerous weapon by a minor. The prosecution now looking to lower those charges to get a possible conviction. This is the defense is seeking a mistrial. So what do you make of these latest developments in the case?
It's kind of a crazy case, and it's got a tortured procedural history, and I'll tell you why. First of all, a lot of the prosecution witnesses actually supported the self-defense claim. They themselves said that it was a chaotic situation, that the defendant was confronting a situation in which people were violent and they were attacking him. And now you have the defense witnesses that are coming on and corroborating it. Even the government's expert medical witness said with Mr. Rosenbaum that he could have had the soot injury on his hand because he was grabbing the rifle, which supports what Kyle Rittenhouse is saying. Now, the difficulty with what's going on in the case right now, and why I say it's complex, is because the prosecutor has interceded into this case and put evidence in that should never have been brought in. So I believe that even if there's going to be a conviction, that it very well could be reversed, especially with regard to commenting on the defendant's post-arrest silence on the witness stand in front of the jury. There's also a pending motion by the defense to actually throw the case out because of that comment, which the judge has reserved on. So if the defendant is convicted, you can expect to see a motion for a new trial or even a dismissal of the case based upon the egregious conduct of the prosecutor in the case. So look, as a former homicide prosecutor and a self-defense claim, you have to disprove self-defense beyond a reasonable doubt. Right. And he has his own witnesses talking about a frightening situation. It's not about right. It's not about left. It's not about Democrats. It's not about Republicans. It is about the facts and law of this case, and that's what courts do. And it just takes, again, one juror to not be fully convinced by the prosecution. Let me ask you about the judge. Judge Schroeder has actually kind of become more of a key figure in the case. Of course, the judge always takes a prominent role here, but more people are commenting on how he's handled the courtroom. You talked about that moment where the prosecution brought up the post-arrest silence. We saw the reaction to it. Let me just play that for our viewers, and then I'll get your thoughts.
I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that. So I don't know what you're up to.
Now, some lawyers have weighed in on potentially other networks, calling the judge's actions inappropriate. Did the judge overreact in that instance?
Absolutely not. I don't know what jurisdictions these people are practicing in, the gentility perhaps, but I know the jurisdiction in New Jersey. If any, for far less, I've seen judges tee off on lawyers outside the presence of the jury to basically set the tone. You are going to stop. Now, when a seasoned prosecutor comments on a defendant's right to remain silent with the defendant on the witness stand, that is such a profound and grave constitutional violation that the judge needed to be able to control him. And that's what judges do. They raise their voice, they point the finger, and they basically spank the lawyer to tell him, this stops now. And this wasn't the first time that it happened. This was right on the heels of after the Fifth Amendment violation. He then introduced evidence that the judge said could not be admitted into evidence, saying, I feel like I could do it on my own. So no, this is a judge that, by the way, by reputation is a forceful guy. This is the way he is on all of his cases. And you know what? When I was the head prosecutor, after this case was over, that prosecutor would be fired for having commented on the defendant's right to remain silent. This was not an accident. This was an act of desperation.
All right. We'll leave it at that. Very heated trial. Bob Bianchi joining us with his thoughts. Thank you, Bob. We appreciate it.
My pleasure.
Thanks.
My pleasure.